So the tribunal, which is single-handedly handling the IBC and the company law jurisdiction. What I'll do is I'll let the panel introduce themselves, 1 minute to each of them, and then I'll introduce myself. Is that good?
Hi, good afternoon, everyone. I'm Reeva Singhal. Currently, I'm leading IP and corporate litigation for Reliance Retail and have been around for almost 2 decades. Look forward to this extremely, I would say, fiery discussion. It can go either way, yeah. So, yeah, look forward. Thank you.
Thanks. So I am Mukul Shastry. I'm the Group General Counsel for Cube Highways. We are a Singapore-based private equity platform. We invest into roads and highways sector in India, and we are the largest toll road operating company, private operating company in India. So most of the tolls that you might be paying in and around Delhi or even South India, you might be paying the toll to us. Almost 10,000 lane kilometers that we have right now. So I had legal, compliance, contract insurance, and looking forward for the discussion.
Hi, good afternoon, everyone. I'm Anoop Rawat. I'm the National Practice Head of Restructuring and Insolvency Practice at Shardul, Amarchand, Mangaldas. We focus primarily on the stress asset resolution, whether outside the insolvency or in the insolvency. Look forward for the discussion here.
Good afternoon. I'm Rashmi Kathpalia. I am former GC of 2 MNCs. I have about 3 decades plus experience behind me, including about 10 years with litigation. And I used to be, once upon a time, official liquidators counsel before the company court, and that's how far back my knowledge is regarding insolvencies and winding ups, etc. So I'm very excited about today's topic and how it's developed over the decades. That's all.
Yeah. Hi, my name is Amit Maheria. I'm the managing partner in MCO Legals, having a practice for about 24 years now, and mainly involved in NCLT with restructuring and do a lot of operational creator parts also. I look forward for a healthy discussion among us. Thanks.
So a quick introduction for me is I'm Manisha Chaudhary. I'm the managing partner at UKCA and Partners LLP. My domain is dispute resolution for corporates and in commercial laws, focusing on PE, focusing on company law, insolvency, of course, and also on debt funding. So a corporate ecosystem, I do it all. So that's about it. So we'll start now. With a quick introduction, I mean, most of you know what the NCLT is, and it's in the news for all the good and the bad reasons. So just bringing forward a few facts on the NCLT. Established in the year 2013 with the Act coming in and notified in 2014. The NCLT originally was for company law jurisdiction and to consolidate the jurisdiction from the High Court in terms of the appeals, in terms of the mergers, and in terms of the winding up, which then became liquidation before the NCLT or the ROC, depending on how you want to go about it. And of course, the original jurisdiction of the CLB was transferred to the NCLT, which was operation mismanagement, strike-off, which had to move in here. Now with NCLT, at that stage, it was a lot of cases being filed. It was a smaller court, but it was still a great forum for company law to be discussed, for jurisprudence to be made, for cases to actually move forward. Then in the year 2016, the IBC came into being, and NCLT became the adjudicating authority for that. And from that started the chaos, or the beauty of that chaos, because it gave us great jurisprudence in the IBC, but it also sort of treated the Companies Act as a stepchild. So today we are here to discuss all the pros, all the cons, the things that came out well from the NCLT, and what challenges today the NCLT is facing in terms of the IBC and in terms of the Companies Act. We'll look at it from a practitioner point of view as well, from GC's point of view as well, and of course we'll open the forum to you all if you have any queries to ask us, any anecdotes which you would want to share, any experiences, that would also be great. So starting off, how we're going to plan this panel is, we're going to have a general question, and I'll have each panelist put in about 30, 40 seconds, 1 minute, 2 minutes tops, to sort of give their view We're going to try to keep it a little generic because we don't want to go into number, figures, name of the cases. I think we all read it in the newspaper every day, at least on the IBC part. But I would like everyone to touch Companies Act issues as well, especially operation mismanagement and M&A, because that's taking a little bit of a backseat in the NCLT and not giving the results that we would have sought the NCLT to sort of give us when it came into being. So I'll start, and I'm trying to be paperless, so please do excuse me from asking questions from my phone. So one of my first question is, just starting with you, Reeva, what are the experiences that you've had before the NCLT from a GC perspective? Just, you don't have to tell me what cases you have before them, but just as a person viewing the NCLT, how has it gone for you?
Okay, so when you say experience with NCLT, so before Reliance, I was a very active practitioner at the NCLT Delhi for almost 5 years. So, well, experience there was, I mean, I don't know if but from 2016 to 21, I think Delhi NCLT was the most effective benches that we had, for sure. I mean, there were obviously IBC cases were, I think, still our topmost priority. But now, when I look at these from a NCLT or an organization viewpoint, I mean, I think more than the insolvency or the Companies Act cases, somehow I feel it's become, sadly, a court for recovery, or that's how at least people are trying to, approach NCLT. I mean, we've seen cases where, and also because, a civil suit does not grab so many eyeballs. But the moment there's a IBC petition, it is a higher priority when it comes to any organization. So that is one bit of it. And the other bit that we recently experienced was when you look at company law also, any application, be it for operation mismanagement, recently we saw something where there was a request for SFIO investigation, and the fact is that on the face of it, sometimes as any practitioner or an organization, you know that this is something that you will get done. I mean, you see that there are no merits. But unfortunately, the system is such that, an application or a petition sometimes takes over 3 years to get dismissed. And the moment, as GC, I mean, I'm sure Mukul will agree, that the moment you have an application like that pending, it is at times something which becomes difficult for you because you're fantastic on merits. This is not something that's going to hurt you, but anything that takes over 4 or 5 years to resolve or to get dismissed is something that, becomes an extremely difficult task for us to explain to the stakeholders. So yeah, that is my 2 bits on it at the moment. But I don't know how Mukul's experience has been. This is.
So Mukul, anything specific in your
So
field?
2, 3 things there. So one is very recently we have completed a deal through NCLT. The deal is CNTL. It is in public domain, 5,400 crores. So NCLT, or rather IBC, has been really a game changer for India, as far as the investors are concerned. Really, it has an investor pull because the earlier mechanisms were not that great, and definitely IBC has been a game changer. Obviously, there's still lots and lots to be done, and I'll just give you 2, 3 small statistics and things as to how IBC has the cons of it. Number one, as what Reeva said, the delay. And obviously there are timelines in IBC, but if you see and if you simply do a normal Google search, the average time taken for a disposal is almost 650, 670 days, which is too much. And see, from an investor perspective, it's all IRR driven. So if I'm investing in something and I think, okay, in 1 year time, I will get this project with me, and therefore it will up and running for me. So I have made my calculations that, okay, this is what I have to pay, basis this project will come to me after 12 months. Now, if it doesn't come to me in 2, 3 quarters, if the delay is, instead of 12, it comes in 24 months, if there's a delay of, say, 4 quarters, every quarter erode almost 2% of my IRR. So what I'm going to get after 2 years, which is the average time, 650 days, is of no use to me because almost my IRR would have been eroded. If I have planned for a 12% IRR, a 1 year delay means my IRR has gone back to, I don't know, 4%. It doesn't make it a commercially attractive deal at all for an investor. Therefore, this this delay we have to really stem, and we'll see and we'll discuss how to work on these delays. But yes, overall, IBC has been a fantastic tool for us. But yes, there have been these delays, and which are a cause of concern.
All right. So just before we go to Anoop, I'll just give a few statistics that I had noted down. So NCLT, right, we know is handling about 4 distinct jurisdictional pillars. The corporate CIRP, right? So that's about 38,702 cases filed, and about 37,233 disposed with a 97.2% disposal rate in Section 7 and 10 mostly. The liquidation proceedings is about not really doing that well. So about 33% of the CRPs have been closed through liquidations. The pre-packaged insolvencies, which I don't see really going through the NCLT or people really filing those for some reason, those are about 500 to 600 only, and they're not really doing much in terms of the money involved. However, the Companies Act is sort of they say 94% approximately is the disposal rate, but it is taken a back seat from what most of us understand of those who had been practicing the company law before the NCLB and the NCLT. So Anoop, just taking those statistics, not only focusing on the insolvency part of it, because I know that's your practice area and you're the master of it, but something on the Companies Act as well as to what you may have seen your other partners facing, or maybe you are yourself.
See, I think the topic today is multi-layering within a single tribunal. So if we talk about that in the context of NCLT as a tribunal, as you rightly said, that NCLT performs the role of a tribunal under multiple laws. Of course, there are some laws which are economic legislation like IBC, which have the urgent need of quicker resolution. What Mukul said, that their IRR changes, so you can't have a case lying there for multiple months, forget about a year, multiple months, which changes the whole dynamics of the investment decision. As compared to, let us say, an operational management, which is more like a, how the management should function. So I think the focus and the objective are different, but are within the same tribunal. Therefore, I think we need to fix the design of the tribunal per se. At the moment, it's a bit commingled. The same bench is looking at all the aspects, and increasingly, we will have much more nuances coming in even in the insolvency space. See, so far we have dealt with cases where you have the asset-heavy resolution, right? Now, with AI, introduction of AI, e-commerce, and AI failing, you do not have asset to take a recourse on, for example, Bitcoin insolvencies. So I think it will become much more nuanced. So I think the need is that within the tribunal, they need to have specialized benches. There should be a specialized bench which should cater to only the operation mismanagement or the other merger-related and other issues. There should be specialized benches who only look at the investment resolution aspect of the insolvency. And that should not get commingled with the other insolvency aspects. For example, avoidance transactions or any other interventions, left, right, center, which keeps on happening. So I think that specialized bench which is looking out only at the time value of money perspective, where there are defined rules, and that is intended to give a very clear, decisive indication to the investors that, oh, we are taking care of your investment and their IRRs, and we are not going to take too much time. And it is very much possible. So I think the design, once it gets fixed, and it's not that, the various stakeholders have not thought about it. There have been, the Law Commission report on how the tribunal should be rearranged. There have been, industry houses like FICCI and all, they have prepared report around that. I think if we take that and also remove some of the control that the existing administrative ministries have over the tribunal, if we take that out and then put it under much more neutral ministries such as Ministry of Law and Justice, and create those segments, I think we will have much more efficient processes.
Right. So, Rashmi ma'am, From your experience as the counsel for the OL, and you must have appeared before the High Court, and changes from that jurisdictional aspect to the NCLT, how do you feel what has changed over the years, or has been your experience, good, bad? Just share that with us, please.
So going back several decades, while there was the CLB and there was the company court, things were working really well. But I think one of the reasons why this NCLT was created was to take away that workload from the High Court and for CLB, all that to be put together under one capture-all kind of a tribunal. And it has been the times of tribunals. Many other statutes also have tribunals coming into their new forums have come in, like NGT, and there was CSTAT, and of course the tax tribunals were always there. So the thought process for that was to have to have all company law related things under one roof. That somewhere has gotten lost because we are now looking at, like Reeva mentioned, recovery. I mean, everything has now, it's not as if winding ups weren't filed at that point in time to extract money back from whoever was the lender. But now what is happening is the NCLT is looking at all and sundry and nitty-gritties, even if it is somewhere convoluted and connected with either the insolvency or the recovery of any funds from a debtor. Having said that, the pros are that now we have everything under one roof. But the con is that this roof is about to collapse because it has again gotten overloaded with all the work that was there with the High Court at that point. So although they have created the appellate tribunal also, but that appellate tribunal is also not giving the kind of orders and awards that were given at that point in time by the High Court, which were followed, which were implemented. For some reason, our NCLTs are now just doing corporate governance. They are doing, giving smaller orders or just safer orders or micromanaging and not really getting to the crux of the matter that an insolvency now is taking three years to even get resolved in the smallest way. So somewhere around the line, we have lost, I think, the practitioners, the people who are filing before NCLT, using it for purposes that it was not meant for, just as dilatory tactics. We are finding that NCLT is not working the way we were wanting it to work.
Amit, a more microscopic view from a practitioner's point of view as to what you see and your experience before the NCLT. It could be generic, it could be specific, whatever. Take it away.
Thanks, Manisha. You know, India is a big country, so definitely there's a lot of business, so a lot of companies. So volume will be there, whether it was under the company when it was with the High Court, or now whether it is with NCLT. The issue which Mukul, everyone was highlighting, it's correct that now people think of NCLT and they just think about IBC. People are forgetting, or even within the legal fraternity, they're not thinking that there are companies and all. So burden is there. My personal experience is the timelines. Timelines are not being met because of infrastructure issues in the NCLT or the benches are not. Multiple applications are filed. I've seen that the NCLT is crossing its line in the sense that trespassing into the jurisdiction of other entities. Few examples. It starts deciding how the RP should function. What should the RP do? How RP should decide. It starts deciding how the COC should function. You know, those are the commercial wisdom. Supreme Court has been very clear that you cannot interfere in those. Now you look at the Section 9. It has started acting like a civil court. It is taking evidence, it is evaluating evidence without the assistance of CPC and coming to a conclusion whether a document is correct or not correct. And the whole thing, why it becoming a serious issue is that at the end there is a threat that overnight your management may replace. That threat is there, so it's being abused by litigants, and to certain extent, NCLT is allowing it to be abused in the sense going into evidence, going into the area of RP functioning. So these are our concern, and wherever in various conferences we have always said about how it's become a civil court and it is just appreciating evidences and it's deciding whether a lease is correct. It is deciding, like whether the admission document which I have denied, whether it is correct or not. Those are not NCLT's functions. They should have just similarly, if it's disputed, just leave it to the civil court for decide. So concern is delay. From delay is the interference in other jurisdiction. Thanks.
Starting with you again, something good about the NCLT. Since it's come into the being, how do you see it has changed the corporate jurisdiction or the commercial jurisdiction even when it comes to the insolvency part?
I think taking into account the globalization and the Indian economy, the way the decision to bring everything under a roof is a correct thing for a corporate world. It's easier, and NCLT has, whether right or wrong, it has created an environment where people are scared of defaulting. There is in the business community, there is whether I get an NPA or whether I'm warned and all that. So like ma'am was mentioned about recovery, so every positives have a gray line where you cross. So in the NCLT case, I think that the default has reduced overall in various legal transactions, and that has happened, and the organization has become far better. NPAs have reduced so much in the banks. So overall, it is a very positive step. There will be backdoors that can be overcome.
Right. Your views, Rashmi?
So same as what I would say that the recoveries of the NPAs has marginally increased, but at the same time, when these smaller insolvencies, startups which were hesitating from going and developing into more serious matters, they find it easier to go to NCLT and get their mismanagement and oppression resolved. We've seen all this time, it was always the bigger companies who were going, their big shareholders were going. We've also seen that now NCLT is trying to get matters settled. There's a little bit of mediation is also coming in. So those pros are working towards NCLT. It's expanding its spheres. That expansion is not necessarily going out of the statute, but laterally into resolving issues.
Right. So just adding to what you had said on mediation, and mediation being part of insolvency is one thing that is being proposed, but mediation is already there in the Companies Act, and a mediation panel to be made by the RD, depending on where the RD is located, to something for all these derivative suits, shareholder litigations, which is something which can really work also in class action, in my opinion. So Anoop, from you.
I have a slightly different view. I think that there are definitely certain shortcomings, but even with these shortcomings, the NCLTs have been able to achieve a great lot of things actually. You see, nobody would have thought of changing some of these bigger names that were there, the promoters that which has happened in the NCLT, and NCLTs do draw a lot of power under IBC to do that. I think the only things that we see are lacking is in terms of the focus on certain time-sensitive issues, which is resolution, and we need to sift it from the other aspects. Then the infrastructural issues, which is an easier thing to I think sort out, and of course more and more training and more qualified people getting attracted to join NCLT. I think with that, I think it's a phenomenal model. It has worked really well. If you look at how some of the other jurisdictions face the issues. I mean, for USA it took more than 100 years to sort of come to the place where they are, and we are already there. So I think though the transitioning issues definitely are there, but we are doing well overall.
Yes, Mukul. Good things only.
Yeah, good things only. What No, I just take the cue from what Anoop has said. No, I feel, yes, IBC has been great, and I said that it has boosted investors' confidence, and you can see the proof of the pudding is in the eating. If you see the number of cases, it has become threefold in past 8-10 years. So yes, it definitely is attracting a lot of people. Though people are misusing it also a lot. There are a lot of people who are just filing cases and using NCLT and IBC as just a civil suit recovery, money recovery thing. But then that will always be the case. There are a lot of intervention applications, this and that. But then that will always be the case. But what I feel is the solution lies in the person who are manning it. And I feel that is where right now the biggest of the issues is. As Anoop has rightly said that I do not know what kind of compensation they are getting, or what is or who are really manning it. Whether the industry people are really going and joining them. Like Anoop said, let's have a multi-layered jurisdiction. The person who are expert in say AI and Bitcoin. But then again, do we expect a retired judge to understand those things and those nuances? I don't think so. So maybe we really change the entire thing. If you really want to have a multi-layered jurisdiction, it's better that we have those kind of professionals attracted towards
At least
it.
technical
That's what I
members
feel.
from the industry would be great.
Thanks. So I think everybody's mostly covered all points, but if I have to kind of bulletize it, I'll say number one would be specialization. I think that has something that NCLT is definitely brought in. So at least you have a bench that pretty much understands what laws we are talking about. So that is one. The second would be codification. There has been, the law, the substantive law has pretty much kept in pace. So yes, these two I would say are the top two. The others obviously being, there is, no matter what we say, but the speed has definitely become better than what it used to be. So yeah, these three top
Yeah, so
bullets.
in terms of the speed, so I have these numbers before me, which is that before in the BIFER, a case for these sick industries used to take about 10 to 15 years.
Absolutely.
Whereas before the NCLT is at 597 days on an average. And the NPA that they have recovered is about 1901,261 crores. So that's a lot of
And
money
also
pushed
there's a
into the
single
economy.
window clearance now. You know
Right,
exactly where to
exactly.
go. You don't have to run to 500 different places. So yeah,
Right.
all these, cannot be overridden by the fact that yes, there are procedural delays. Those are there in every, sorry to say, but every tribunal, every court, sadly the infrastructure does
Right.
need improvement. There is no doubt about it.
Right.
But all these, I would say, achievements or the benefits that all litigants have had since the NCLT has been set up cannot be taken away.
Right. So, Amit, just going back to what you had mentioned with regards to NCLT maybe overreaching its powers in terms of leading evidence or appreciating evidence, I would say, or even trying to conduct a mini trial, asking questions across the bench to the litigants or to the lawyers. Also, comparing that under the IBC with the Companies Act, because in my understanding, NCLT has a far-reaching approach, or could have had it under the Companies Act, even to the extent of maybe not adjudicating on fraud, but giving a prima facie finding, looking at evidence and appreciating it on the face of it, not really leading trial, but trying to understand queries from the litigants and maybe taking a view at least in terms of documents which are before it on affidavit. So from that I understand under the Companies Act, but taking a departure from that and then putting it under the insolvency and maybe letting the rules of the NCLT taking that onto themselves and saying that the rules allow us to do so. So in your opinion, what do you think? I agree that you do not absolutely agree with the NCLT, but what do you think could be their limits or should be their limits, and how they are encroaching upon it, and where, if you, on the flip side, believe what could be, how far they can go into trying to appreciate it, and think of it from not just an angle of corporate debtors, but the litigant also, the persons who are before the court, who are genuinely grieved. We are not going to talk about any litigants who are there just to sort of create a mess. So your opinion, your thoughts on that.
NCLT, I'm very pro. Issue is that when it starts appreciating the documents, what happens, I'll tell you, they file an application. Let's take an example, a section 9. And this application is supposed to be in totality by the code. In totality means it should establish the case that there is a debt and all those things. Then the proceeding starts, a reply comes. Then it goes on to become a rejoinder, a sir rejoinder, a sir rejoinder, and new documents which were existing at the time of filing of the applications are being brought through sir rejoinder, sir. So, it becomes a never-ending process. And in that, it is very easy for NCLT to not appreciate where I should be stopping. So that is the concern. So it is also for the advocates too who are appearing for the litigants to ensure that it doesn't happen. So, but it is happening and it's become like a debt recovery in that extent.
All right. So from your aspect, ma'am, on the same issue, but only trying to understand what could be bettered. Do you agree with this tribalization of all these specialized things? Because I think we're up on time, not short anymore. So just your thoughts, your last minute like bullets as to what can be done, what should be done, what ought not to be done. What do you think?
I'll just go with what ought to be done. So the tribunalization is what is required at the present moment if we have to get adjudication done for our disputes, and it's not just up to the High Court. So far as NCLT is concerned, I think we just need to improve the number of people that we have over there, the members that we have over there, and have a specialized team to be addressing. Each member has to have a specialization in what they can contribute to, and not just generally educated people in the law. That is 2. 3, very importantly, we need a better infrastructure for NCLT, which is sorely lacking. It's great that we can connect online and have our hearings, but so far as the actual number of people, where they are located, like we were discussing earlier, they get appointed, they don't even have laptops to be working on. So such like small things, but which go a very long way in actually improving the working, and also for NCLT to realize that they are at par and they need to give the kind of orders that actually move the cases forward, and not just macromanage and give corporate governance awards. Those are a few bullet points that I feel
Anoop,
are necessary.
yeah.
Yeah, time is already up, but I will again, I'll come back to the same point. I think we are doing fine. It's just that, we do need to strengthen the existing, the bench strength, the quality of bench strength and the infrastructure aspect. But I tell you one important aspect, if you look at the large Asian economies, you will not have the kind of law that we have. China doesn't allow the foreign creditors to, come directly to the tribunal in China and claim this right which is, parallel to the right, or same as the right of the domestic financial creditor. So it has done, very good service. It has improved the way the foreign investors, the, lenders look at India now. And I think we should just build on it. There are areas of improvement, but I think we are doing fine.
Mukul and Reeva.
Same thing, actually, better infrastructure and let's have the quality people. And I always say that now there are people in industry, there are people who are good advocates. I should think that they should man these things, and we should really incentivize them better so that they join the benches.
To sum up, I think there have been enough judgments also passed by the Honorable Supreme Court which said, structure first, legislation later. So I think that pretty much sums up the need of the hour. So there's no point harping on the fact that, there is delay. I think there is a need of the hour is to work and support on better infrastructure. I think everything else will follow.
So just to sum it up from what we have discussed, and though we were very short on time, NCLT is a great forum. IBC was the need of the hour. We had to get onto that platform with all the developing and the developed nations to have that law into place. They could give more weightage to company law and infrastructure, and if anybody can take this to the government also, and I'm absolutely pro-establishment, but please ask them that they need to give this forum this due worth, and it needs what it needs to be doing better with the benches, with the actual building, people who are working there, admins, and of course us as lawyers should also be able to contribute and hold on to the litigation there and make sure that it is as smooth and as proper as it can be, and efficient, of course. So thank you so much for your patient hearing, and thank you to the panel. You all have been tremendous. Thank you so much.
Thank you so much. Thank you. And thank you, Manisha, for moderating that.